Hello, everybody. I'm Diane Cohen with MacroPro. I want to welcome you to this edition of MacroPro and Friends webinar series for our 12 CEUs. Today, I am joined by Melissa Downing. Melissa, how are you?
Hi, Diane. Thank you for having us. Happy holidays.
Yes, and to you. Can you tell us a little bit about what you do and the name of your firm and just give your company a little plug?
Oh, absolutely. My name is Melissa Downing. I'm the Director of Client Services for Thomas Kinsey, LLP. We're a statewide law firm based with offices in Southern California. We have been around for over 40 years and recently rebranded. You may remember us as SRTK, and now we are TK. And joining us today is our managing partner, Anastasiya Franco from our Orange County office, and Jennifer Kranbuhl from our Corona office in Lynn Empire.
Oh, very nice. Well, they will be able to meet everybody and share their knowledge. That is fantastic. So, Melissa, we were talking a little bit about music.
Oh, my favorite, especially this time of year. If everybody could go in the chat and put in their favorite holiday song, I would love to see what everyone's responses are. I have a 10-year-old, so we listen to a lot of music this time of year. And I'd have to say my personal favorite is Jingle Bells. It's an oldie but a goodie. What about you,
Yeah,
Diane?
your favorite. My favorite is a new song by Cher, and it's Mr. DJ, Play Me a Christmas Song. And I defy anybody to be able to sit there and not start moving. I mean, it just gets you up and moving. It's really, really fun. How about you ladies? Anastasia?
I've been listening a lot to Santa Claus is Coming to Town, also an oldie, because I have a 4-year-old daughter who's in preschool, and that was her holiday performance. So she's been practicing and singing, and I've been singing along with her.
Very nice. Do you have a favorite?
Oh yeah. To piggyback off of what Anastasia was saying, I also have a 4-year-old who just had a Christmas performance, and she's been singing Winter Wonderland. So that's definitely on a loop in my head at this point. But I love this song. It's great.
Yeah, absolutely. All right, well, ladies, I'm going to do a little housekeeping. We're going to turn this over, and I can not wait to see. Okay, so Melissa, maybe you can you see some of the chats? We have Last Christmas by Wham. Oh, yeah, that's a good one, by Wham. Then we have I'm Dreaming of a White Christmas. Jingle Bells also. Let's see, Frosty the Snowman by Nicole. We got White Christmas, Brandy, Wham, Last Christmas. That's fake. That's a favorite one. Hi, Patricia. Patricia's been to a lot of these webinars. Good to see her online with us. Then we had, did you hear what I hear? That's a good one. Silent Night. So there's some really good picks that people have, and a lot of them are old classics. I love that. All right, so for our housekeeping, this is what we're doing. This webinar is worth 1 CEU. You should receive it within an hour after the presentation. You must be logged on to the GoToWebinar platform in order to receive it, and you must be using your own link, because otherwise the certificate will show up in the other person's name. And we can't change it because we can't do any time and attendance for you without having your own link. If you would like the handouts from today, please download them now. They are attached, so please do that. If you have any questions you'd like to ask, put them in the question box, same ones where you filled in your favorite Christmas songs. And Melissa and I will be watching that to see about asking those questions. And then lastly, this will be on YouTube, and you can watch your comment performance there. All right, everybody, good luck. Have a great webinar.
Thank you, and I'll kick it over to Jennifer and Anastasia.
Thank you all for joining us to discuss the art of legal apportionment. Today, we're going to provide you with practical tips on how to identify apportionment that may not constitute substantial evidence, and how to rectify those issues so that we can rely on these reports that are beneficial in terms of apportionment and overall value, and secure a reasonable settlement based on us being able to rely on those reports. We're going to address what does and does not constitute legal apportionment, including the required elements for legal apportionment, in addition to relevant and some interesting case law on this topic. Slide, Melissa. Next slide. So there are 2 labor code sections that deal with apportionment, right? That directly deal with apportionment, 4663 and 4664. The first statutory basis for apportionment is 4663, which states that apportionment of permanent disability shall be based on causation. And any physician who prepares a report addressing the issue of permanent disability must address the issue of causation and apportionment. For a medical report to be complete and to constitute substantial medical evidence, a physician must make an apportionment determination and outline the percentages of permanent disability caused by the industrial injury, as well as if there's any factors to non-industrial causes as well. Slide. So while Labor Code Section 4663 deals with medical apportionment, 4664 deals with apportionment where there is a prior award. This is known as presumptive apportionment. So 4664 states that the employer shall only be liable for the percentage of permanent disability directly caused by the industrial injury. If the applicant has received a prior award of permanent disability, it is conclusively presumed that the prior permanent disability exists at the time of any subsequent injury. This labor code actually goes into where you have 100% permanent disability, but it indicates that you cannot have 100% of any one body part. So it does give you the regions of the body that applies to. So hearing, vision, mental and behavioral disorders, spine, upper extremities, including the shoulders, lower extremities, which includes the hips, and then there's head, face, cardiovascular system, respiratory system, and all other systems. And this is specifically laid out in the labor code in these regions of the body. So the permanent disability for all different regions of the body when arising from a single injury after being added together shall not exceed 100%. Next slide. So apportionment per Labor Code Section 4664 does seem straightforward enough. Well, you have a prior award that's presumed to have existed at the time of the injury. However, being able to use that for apportionment in the current case is not necessarily as easy as it seems. So any prior awards of permanent disability are conclusively presumed to exist at the time. However, there must be overlap between the old award of permanent disability and the new award of permanent disability. It's defendant's burden to prove the overlap of the prior award. So even if a prior award exists, it is defendant's job to prove as to what extent that prior award of permanent disability overlaps with the current injury in order to qualify for this presumptive apportionment. And many of you may have run into this. This makes apportionment to prior awards difficult where they're much older cases, and where maybe you don't even have a copy of the award, or the award has been destroyed because it's so old, and also where the award is under the old schedule. So arguably, there's no overlap between the old system that was based on subjective complaints, objective findings, work restrictions, and then the new system, which is based on something entirely different under the AMA guides. So if you have an old award, a lot of times that might be a lot higher than what something would be under the AMA guides, but that doesn't necessarily mean it's wiped out, because at that point you're comparing, you're not comparing apples to apples, oranges to oranges. And you're not going to be able to just say, okay, well, they got a 50% award for the back previously, and now it's 10%, and so there's nothing there. There's a lot of work to do to get it to the point where the conversion basically is the same, so that you can subtract or have that presumptive apportionment. A lot of times it's easier to get the medical apportionment on those things. So having the doctor address, okay, they had this prior injury and I'm apportioning 25%, say, as an example, to this prior injury under medical apportionment, and having them explain why, versus trying to get an old schedule case converted to a new schedule case to get that presumptive apportionment. Another consideration is where you have an order approving compromise and release for this prior injury to the same body part. That does not constitute a prior award of permanent disability. The WCAB has indicated that when parties agree to a compromise and release, a lot of things go into that compromise and release, more than just permanent disability. And it could be settled on a range of permanent disability where nothing is finalized or agreed upon. And so it's unclear as to whether a CNR can be used for Labor Code Section 4664 apportionment, even if it specifies a certain level of permanent disability within the documents. However, this is kind of what I was getting at before. A CNR and corresponding medical reports can be used as a basis for medical apportionment. So just because you have a prior award doesn't mean that we can't concurrently try to seek the medical apportionment under 4663. And sometimes it's easier to have a doctor explain that. So in a situation where there is a prior award under the old schedule, you will need a current QME to comment on the overlap. New slide. So Escobedo is probably one of the most well-known cases that discusses what is needed in terms of an apportionment discussion that constitutes substantial evidence. So in the Escobedo case, the WCAB held that the reporting physician must make determinations of what percentage of permanent disability was directly caused by the industrial injury and what portion was caused by other factors. So we all know that it's the applicant's burden to establish the percentage of permanent disability. However, it's defendant's burden to establish apportionment, okay? So apportionment of permanent disability caused by other factors may include pathology, asymptomatic prior conditions, and retroactive prophylactic work restrictions. However, there must be substantial medical evidence establishing that these other factors caused permanent disability. The key to understanding apportionment is spelled out in the Escobedo decision, and many of us may have heard this saying before, how and why. The doctor must explain how and why the apportionment applies for it to be considered substantial medical evidence. The how refers to the direct causation of the disability, and the why refers to the estimated percentage of the disability caused by the non-industrial factors. Can't say this enough. Mere statement of percentages is not enough. There must be a discussion that is supported by facts that medically relate to the percentage of apportionment in a reasonable and compelling manner. Next slide. So the Yeager case that's cited here, it helps us define the term substantial medical evidence, which is required to prove any medical issue, not just apportionment, but anything medically that we're trying to prove on the case. It has to constitute substantial medical evidence. And the evaluating physician with respect to causation must explain the rationale for the finding of apportionment to causation. For a medical opinion to constitute substantial medical evidence, it must be framed in terms of the magic words, reasonable medical probability. These words must literally be used in the report for something to, for an opinion to constitute substantial medical evidence. The opinion cannot be speculative, and it has to be based on pertinent facts and reasoning in support of a conclusion. Next slide. So just a summary of what apportionment analysis is required under the Escobedo decision. So apportionment must be discussed. Even if ultimately there is no apportionment, in order for a report to constitute substantial medical evidence, it has to have an apportionment discussion. The burden of proof is on the defendant regarding apportionment, and we'll discuss a little bit later why that's so important to remember that. It's our burden to prove that. And there's things that we have to do in order to beef up that opinion so that we can rely on it. Apportionment must be based on substantial medical evidence, which is defined by the Yeager case. The doctor's opinion must be based upon a reasonable medical probability. Those words must be used, and factual support and analysis are required. The key is analysis. The doctor must provide not just a mere conclusion, not just mere percentages. They must go into detail with a discussion as to the how and why. Next slide. Apportionment under Benson is kind of a little sub issue for apportionment that we wanted to make sure we covered because it's important. In Benson, the WCAB held that the legislative change to 4663, creating apportionment to the causation of permanent disability, requires apportionment to each identifiable injury that caused some amount of permanent disability. So if the medical records support apportioning permanent disability between multiple injuries, and that could be specific and or cumulative traumas, there would be separate awards of permanent disability for each injury. And Benson apportionment, we defendants love Benson apportionment. If you can establish it, it lowers the overall value of the permanent disability in the case. Where the I guess defense, so to speak, for Benson apportionment is where you have a doctor that says the injuries are inextricably intertwined. That's like not anything the defendant ever wants to hear, because that means that we can't apportion out the injuries individually, and it's just going to be under one date of injury, which is going to keep a potentially high permanent disability value on it. But like anything else, if a doctor is going to make that determination, it needs to be supported by substantial medical evidence and an analysis. So if you do hear those words, we can definitely challenge that. You might want to take a deposition to further get an analysis as to why he's unable to apportion out between those injuries. So as everything else, Benson apportionment must be supported by facts and analysis set forth by the doctor in order to constitute substantial medical evidence. So a doctor can't just simply say, okay, this specific injury is 50%, this specific injury is 50%, and leave it at that. An analysis is still required for that to constitute substantial medical evidence, and for us as defendants to be able to rely on that to reduce the overall value of permanent disability. Next slide. This slide is kind of more of like a practical tip, I would say, and just a perspective from a defense attorney, things that we see when we're in front of a judge, at the board, at trial. The WCAB has a duty to develop the record. We've all heard that. However, I say here may not apply to apportionment, and I want to explain what that means. So there's been many times where we have done everything we think we need to do. We're at the board, ready to go to trial. Let's say that there is a case that orthopedic injury is like let's say orthopedic is accepted. There's add-on claims of psych and internal, okay? We get an orthopedic QME, we get this report, we reach out to applicant's attorney, we try to settle, we don't get a response, we file a DOR, it gets set for trial because we're unable to settle. We get down to the board and the doctor says, well, what about the psych and the internal? And it's like, applicant's attorney did nothing to pursue these additional add-on claims. They didn't object, they didn't get a QME, there's no treatment. But because it's pled, a lot of these judges are saying, well, I have a duty to develop the record. It's pled, and so we need to go to QMEs on these things. No medicals have been obtained to address these additional allegations. So essentially, applicants are getting like a second bite of the apple. They're not diligently pursuing discovery, but these judges are saying, well, we need additional discovery on these issues. I don't think that applies conversely to apportionment. So if we get down to the board and we have, for lack of a better term, a crappy apportionment discussion in a QME, do you think the judge is going to say, oh, I don't think this is an adequate apportionment discussion, and take it off calendar for further discovery so we can go develop the record on apportionment? The answer is no. they're not going to do it. And as Anastasia is going to explain, actually starting on the next slide, there's a really important case that specifically talks about that. That that if these QMEs don't at the outset provide substantial medical evidence to support their apportionment discussions, they're not going to give us a second bite at the apple. They're not going to take the same stance on their duty to develop the record. We can't rely on a judge or the WCAB to fix a lacking apportionment analysis. Instead, defendants must have all their ducks in a row on apportionment before setting the matter for trial. If an apportionment analysis is lacking, that needs to be identified as soon as possible, and the burden is going to be on the defendant to substantiate and rehabilitate it. That means timely objecting and requesting further opinions from these QMEs. A lot of times we get these reports from a QME and we might initially be blinded by it because it's like, oh wow, this is an amazing report. He apportioned 50% to non-industrial, and we're like excited, whatever. I'm telling you, the higher the apportionment percentage, the more work we have to do to make sure that that's solid. Because the judge is going to see that, and they're immediately going to have, for lack of a better term, a bias, like, oh, that's not, like, how are you getting to this? The scrutiny button is going to be pushed way up. And so it's just super important that even if we think we have a favorable report, we might still recommend we take a depo, a cross-ex, get a supplemental, do further discovery on it, just to make sure we can reasonably rely on that opinion. Hopefully that makes sense. Does that have been your experience too, Anastasia, down at the board?
Yes, absolutely. And it's almost counterintuitive because you get this report and there is a 1 or 2 sentence discussion about apportionment, and it's great, right? It rates out great, and maybe that's just enough to keep you out of life pension or keep you, within a reasonable settlement territory, but don't get excited because, that's deceiving. And the reason I say it's counterintuitive is because typically when we get a favorable opinion, we don't want to cross-examine the doctor, right? Because you don't know what they're going to say during the cross-ex or what kind of path they're going to take, but you have to, even if you have a favorable apportionment discussion, but there isn't enough analysis, the doctor doesn't address the factors or the conditions for the apportionment. I can't tell you how many reports I have seen in the last year that 1 sentence apportionment discussion. Absolutely no analysis, no support, or you cross-examine the doctor, try to clarify apportionment, and they say something like, well, I tried to be fair, or I did my best. That's not enough. And that seems to be the recurring theme, and that will be on point with the case I'm going to talk about next. But yes, absolutely, that has been my experience, and we do need to keep working on getting the apportionment analysis down from the PQMEs before we go to trial.
And you bring up another good point, which is it's a cost-benefit analysis, right? Oh, we see you.
I have a question.
Oh,
I
okay.
have a question that came through. And the question is, can 2 awards equal 100%? Because you were talking about not equaling 100%. So they want to know if 2 awards can do that.
Can 2 awards, so the rule under the labor code is you can't have more than 100% with the same region of the body. I mean, so potentially, right? I mean, but you're like, those are like, if there are 2 different dates of injury, I don't really know how that would equal 100%. I mean, unless there's a LaBeouf argument there, meaning these 2, have now caused this person to be 100% if it wasn't for these injuries. I hope that answers the question. If not, let us know. But what I was saying was that Anastasia brought up a good point. You really have to do a cost-benefit analysis on some of these. I mean, if you have a 10% apportionment, and are you going to take the doctor's crossings to beef that up? I mean, depending on the level of, I mean, if you're talking life pension, not life pension, maybe, right? But if not, I mean, it's probably not worth it, and also applicant's attorney is probably not going to fight you too much on that. I'm telling you, the higher the percentage of apportionment, the more work for us, because that's applicant's attorney is going to be kicking and screaming, and the scrutiny level is going to be super high from the WCAB. So you're just going to have to, again, just do a cost benefit analysis to see if it's something you really need to beef up, or maybe you can just get it resolved and not have to do all that. So
Yeah, absolutely. And the strategy is different for settlement versus trial. If you know your case is going to go to trial and you have an insufficient apportionment analysis, I would go ahead and try and get that addressed. However, if you're working up a case for settlement, you do absolutely do a cost benefit analysis. And a lot of times applicants' attorneys are much more willing to compromise on apportionment if there's a settlement, especially a CNR involved, and they don't push back as hard on apportionment in the settlement situations versus trial situations, because then at that point they have nothing to lose. And they will absolutely list apportionment as an issue for trial. I think we're ready for the next slide. So there is a recent case that deals with this situation. It's been talked about a lot in the workers' comp community. It deals with apportionment and the burden to establish that. And this case stands for the proposition that unapportioned award of PD is warranted when there's a failure to sustain the evidentiary burden, which is defendant's burden of proof to establish non-industrial apportionment, and where the development of the record is not warranted. I know that's a lot. We're going to break that down. So in this case went to trial. There were multiple PQMEs in multiple specialties. I believe there was at least 4. I know there is ortho, there may have been 2 internal, and then there's psych. And after the initial trial, there was an award of 64%. And I don't think either party was happy with the award, and there was a recon. Applicant attorney alleged that apportionment was not substantial medical evidence. Subsequently, there was a new award which came back higher at 92%. So we went from 64% to 92%. And in that case, I just wanted to read you what the judge found insufficient with the PQME's analysis of the apportionment, and you may see that in a lot of reports because I know I see that in a lot of reports. The ortho PQME said, based on the history of this applicant, I would apportion 80% of her current symptoms to the original injuries and 20% of the CT. That's all he said. There was absolutely no analysis. What original injuries, what conditions did she have? So the court found that insufficient. The internal QME said that this is a complicated case of multiple work-related and non-work-related medical conditions that necessitated multiple surgeries over the years. It doesn't discuss factors or conditions or surgeries. The WCB also found that this was not sufficient analysis. And my favorite is the Psych QME said that he gave his best estimate regarding apportionment. So I see that a lot. And if you see something like that where the doctor doesn't go into detail on apportionment, that's an issue, that's a red flag. Next slide, please. So like I mentioned, on reconsideration, the WCAB substituted its own unapportioned award at 92%, finding that apportionment set forth by the various PQMEs did not constitute substantial medical evidence. I just read you those blurbs. They further opined that while the agreed that development of the record is required when the existing record is not adequate to support final determination, we also note that the party who carries the burden of proof must submit evidence that it is adequate to meet that burden. When the evidence is insufficient to meet the party's affirmative burden, the appeals board will not direct the augmentation of the record where there's otherwise sufficient evidence in the record to support the final determination. So here, even though they found that apportionment analysis was not substantial medical evidence by all the PQMEs in this case, they said, defendant, you have the burden, you haven't met the burden, but I think we have enough to just, get rid of apportionment altogether. They didn't give us a second bite of the apple, like Jennifer was saying earlier. If there's a different, issue, additional body parts or QME specialties that need to be addressed, the judge will say, no, applicant, go develop the record. But in this case, if the apportionment is not sufficient, they'll just get rid of it. And that's very one-sided to defendants. So this is why it's very important Don't get excited if you have a great report addressing apportionment. Make sure that it's a very detailed analysis and the doctor's findings on apportionment are supported, and it's not just one sentence, I did my best or I tried to be fair, because I can't tell you how many times they will do that on cross-ex. When you try to cross-examine them and push and say, why, what other conditions, what non-industrial factors, they'll say, well, you know what, I just tried to be fair. And that happens a lot.
I do want to, this was interesting language in the opinion, that just to show like the level that they're looking at for them to be able to consider it. So they said it needs to identify with particularity the factors and conditions causing the disability. The court pointed out that the QME aggregates multiple factors without a specific and individualized assessment of how and why each factor is contributing to applicants' permanent disability. So this is what they're looking for. I mean, it's a high burden, you know?
Yeah. So the takeaway from this case is that the court's duty to develop the record only appears to go one way. It's very evident in this case. You know, defendants weren't given a chance to go back and readdress the apportionment issues. And the defendant must come to trial with a bulletproof apportionment analysis, cross-examinations, and supporting reports that will be necessary in many cases. So like I said, you know, do a cost-benefit analysis. See, if you're going to trial, definitely make sure that your apportionments analysis is very detailed and meets the burden. If you have an opportunity to settle, you may be able to split the difference with applicant's counsel or come to some sort of a resolution. But this especially becomes very important in high exposure cases, life pension or more, because that minor difference in apportionment may take you in or out of life pension. Next slide. So apportionment on 100% PD cases. Non-industrial factors that affect earning capacity, such as language barrier, lack of education, and legal work status, cannot be used to combat a claim of 100% permanent disability. When deducting apportionment and addressing overall PD on LaBeouf, we briefly touched on it earlier today, it is permissible to apportion the permanent disability first, and then after apportionment, apply LaBeouf analysis to the remaining permanent disability. And that means even when there's valid apportionment, 100% may still be found under LaBeouf. And per Nunes, this is also another recent case. A vocational expert cannot reject apportionment that is medically appropriate under Labor Code Section 4663. Vocational expert must consider apportionment under the same legal standard as physicians, and the law allows apportionment to pre-existing non-industrial factors, even when they were not disabling before the industrial injury occurred. Next slide, please. So the Nunes case deals with vocational apportionment. There is no vocational apportionment when a party seeks to rebut a strict rating. And the facts of that case, there's an orthopedic PQME who apportioned 40% of applicants' cervical spine impairment to non-industrial degenerative disc disease and 60% of applicants' carpal tunnel syndrome to pre-existing non-industrial factors. Both vocational experts found that applicant was non-feasible for vocational rehabilitation. Defendant's vocational expert apportioned 10% of applicants' non-feasibility to non-industrial medical factors. Applicant's vocational expert failed to fully consider the non-industrial medical apportionment provided by the PQME. In this case, the trial court found that applicant sustained injuries to her cervical spine, upper extremities, left shoulder, resulting in 100% permanent total disability. And of course, defendants appealed. The issue in this case is that the apportionment analysis described by the PQME is speculative and not substantial. This is what applicant argued, and that applicant is entitled to a unapportioned award. Applicant further contended that vocational evidence may be used to characterize and quantify permanent disability, and that the vocational opinions expressed by vocational experts may differ from the medical evidence. Applicant asserted that the prohibition against using vocational apportionment in the place of otherwise valid medical apportionment will result in pass-through apportionment that is not substantial evidence, and the defendants fail to meet its burden of proof under Section 4664. Next slide, please. So in this court, the WCAB found that the labor Section 4663 requires a reporting physician to make an apportionment determination and prescribes the standard for apportionment, and that labor code makes no statutory provision for vocational apportionment. Vocational evidence may be used to address issues relevant to determining permanent disability, and vocational evidence must address medical apportionment and may not substitute impermissible vocational apportionment in the place of otherwise valid medical apportionment. A vocational expert cannot offer competing or alternative apportionment analysis because it is inconsistent with Labor Code Section 4663. Apportionment of permanent disability under Labor Code Section 4663 authorizes and requires that apportionment determinations be made by the evaluating physicians. Next slide. Here, the WCAB en banc disagreed with applicant and provided a comprehensive opinion touching on several important issues. The first is the well-established rule under Escobedo that medical evidence must adequately address apportionment and explain in detail and within a reasonable medical probability as to how and why non-industrial apportionment exists. The WCAB also noted that Labor Code Section 4663 addresses medical apportionment and makes no reference to and provides no basis for any other type of apportionment, such as vocational apportionment. Vocational experts are bound by medical apportionment in their analysis. WCAB affirmed vocational evidence can be used to address issues of permanent disability and can be used to rebut the schedule. Next slide, please. So the takeaway from this case is make sure that any non-industrial apportionment is supported and meets the Escobedo criteria that we touched on earlier in today's presentation. And always ask the PQMEs to address the issues of whether the factors giving rise to applicants' non-feasibility for vocational retraining as identified by vocational experts are themselves subject to medical apportionment, or whether applicants' inability to participate in vocational retraining is attributable solely to current industrial related conditions or factors. Just be aware, even if there is valid non-industrial apportionment, if non-feasibility is due solely to the industrial components of applicant's disability, a finding of 100% permanent total is permissible, and all vocational reports should be reviewed by medical legal evaluators and vice versa. So if you do have a conflicting report from a vocational expert or experts, make sure you send them to the PQME and make sure that you provide those experts with the PQME's reporting as well. Jen, did you have anything to add on the last case before we tied this all together?
No, just like you said, from a practical standpoint, that we just have to have the QMEs look at the VR reports if there are any, and address apportionment. That apportionment's a medical issue. That's all there is there. That's all there is to it. So we got to have the doctors to address it. So yep, that's it.
Okay. And we have some practical tips for you on apportionment. The first one is never take it for granted. Like I said, when you see great apportionment, just make sure it's really supported. Do what you need to do a cross-sex, request a supplemental. Cost-benefit analysis, and this is an important one. If you can settle a case without, spending a ton of money on discovery or QME cross-examinations or supplemental reports, and maybe bridge the gap with applicants' counsel on settlement. And like I said, in my experience, the apportionment is less of an issue when we're trying to settle, especially if it's not that significant, versus when the case is getting ready to go to trial. Try always do early diagnostics, even well before the PQME evaluation, so the PQME has everything they need. Build a legal record, and that includes, the cross-examinations, deposition testimonies. petition for new and further disability and apportionment. So I think what we're trying to say here is that there isn't, if there's an award and then there's a petition for new and further disability filed, the apportionment discussion that we had today to the prior award doesn't apply. Basically, if you had an award at 18%, an applicant filed a timely petition to reopen for new and further, and they go to a PQME evaluation. PQME evaluations come back and says, well, now, after you rate it, it's 22%. The 22% takes place of the 18%. That's a different discussion than the apportionment discussion that we had earlier today. And the last one is be a guardian of the apportionment galaxy.
It's defendant's burden. I think that's the point we're trying to make. And, just to kind of go back to build the legal record, I mean, not to state the obvious or anything, but, take a dep. We got to take these applicants' depots and get all the records. It's worth it. It's worth it to invest in getting any potential location that they're testifying to. You don't know, what you're going to find in there, but ultimately, if apportionment is going to apply, and we're going to want to rely on that apportionment, it's going to have to be based on something. Can't be based on speculation. We want these doctors to be able to, give them the information that they need in order to give us the analysis that's going to be able to have us reasonably relying on these apportionment findings. So it's super important to get all of these records. I mean, there's a lot of them are voluminous, and I know it's expensive for these QMEs to review these thousands of pages, but if we want to get that apportionment, it's absolutely necessary. Can't get around it.
Yeah, absolutely. And my policy for applicants' depots is you don't know what you don't know until you take that depot. And you may have a case that looks straightforward. Maybe it's a specific admitted orthopedic injury, but you don't know what's going to come out during the deposition and what other injuries they may have had.
Yep. Get those records. I want to make sure, I know the person who asked the question earlier, it says here, if one award gave out 50% and the other gave out 60%, two different dates of injury. I just want to make sure I answered. So to me, that's Benson apportionment. So you have two different dates of injury with that would be allowed. However, it can't exceed 100% for the same region of the body. So if it's back for 50 and back for 60, I mean, I think you have some medical apportionment issues there too, right? To try to reduce those.
Absolutely.
Down. So I hope I answered the question on that. I hope I understood correctly, but let us know. Okay, is there any other questions that we can answer about apportionment or anything? No? Okay. Can't hear you, Melissa. I think you're on mute still.
My apologies. I don't see any more in the chat. Let me just check. No.
Okay. Great. This is our contact information. We're happy to answer any questions, general questions, anything. We love doing that. So
yeah, absolutely.
anything we can do for sure.
Okay, well, I guess we'll wrap it up unless there's any other questions. Thank you guys again for your time and joining us today. And we wish you all a safe and healthy, happy holiday season, and cheers to 2025.
Happy holidays, everyone. Thank you for joining us.
Holidays.
Thank you.